attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the fourth Lawcast in a series discussing SEC comments and responses. As discussed in the first Lawcast in this series, the SEC Division of Corporation Finance, referred to as CorpFin, reviews and comments upon filings made to the SEC for the purpose of improving and enhancing disclosure. Also, as previously touched upon, the comment letter and responsive letter process continues until CorpFin has no further comments. If the reviewed filing is a Securities Act registration statement, such as an S-1, the CorpFin staff will verbally inform the company that it has cleared comments, clearing the way for the company to request that the SEC declare the registration statement effective. When the reviewed filing is an Exchange Act filing, such as a Form 10-Q or 10-K, CorpFin will provide the company with a letter stating that it has no further comments. Comment letters and responses are posted on the EDGAR database by CorpFin approximately 20 days after it has finished the review process. In each letter responding to SEC comments, the SEC requires an affirmative statement from the company acknowledging that it cannot use the SEC's comment process as a defense in any securities-related litigation. This language is referred to as a Tandy letter. The Tandy portion of a response must be agreed to by the company itself. So if the response letter is on attorney letterhead, a signature line must be provided for the company, or the company can submit a separate letter. The Tandy language for an Exchange Act filing requires the company to acknowledge that the company is responsible for the adequacy and accuracy of the disclosure in the filing. Staff comments or changes to disclosures in response to staff comments do not foreclose the SEC from taking any action with respect to the filing, and the company may not assert staff comments as a defense in any proceeding initiated by the SEC or any other person under the federal securities laws. The Tandy language for a Securities Act registration statement, such as an S-1, requires the company to acknowledge that should the SEC, acting pursuant to its delegated authority, declare the filing effective, it does not preclude the SEC from taking any action with respect to the filing. The action of the SEC or the staff in declaring the filing effective does not relieve the company from its full responsibility for the adequacy and accuracy of the disclosure in the filing, and the company may not assert staff comments and the declaration of effectiveness as a defense in any proceeding initiated by the SEC or any other person under the federal securities laws. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of Lawcast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.